So we're going to talk a little bit about how you, as a business owner or somebody that has valuable information, how do you protect it and how do you enforce your rights? Well, part of that is about knowing that you can go to court if you need to, but to begin with, you enforce your rights by managing closely the relationship that you have with the people that you have to share the information with. Now, it starts by understanding that these days, every business has to share its information to some degree or another in order to operate. The days of the fully integrated company are long gone. In order to innovate, we need to partner with our supply chain, with customers, with other business partners. And so we enter into these relationships where we give them some of our information, they give us some of theirs perhaps, and we have to figure out how are we going to make sure that each of us is doing what we're supposed to do. The same is true of employees. We have 10, hundreds, maybe thousands of employees. They all have smartphones that they use to access the company's systems. And so you trust them with this very sensitive information. How do you enforce those rights? You do it by carefully managing the relationship, which starts with a contract that you go through very carefully to make sure that it does the things that you want to do, and then you carefully enforce it. Throughout the time of the relationship, pay attention to the things that the other side needs to do and what you need to do. For employees, that means training. It means constant communication about what it is that you consider to be sensitive and what is it that they're supposed to do to take care of it. For your relationships outside the company, it means paying attention to the contract, how you mark information that you're showing to the other side. What do you do with the information that you get? And at the end of the relationship, how careful are you about cleaning up and returning things that are called for under the contract? So the enforcement of trade secret rights starts with your own management of the information to keep it confidential. If for some reason that doesn't work and the person or company that you've trusted with the information doesn't comply with their obligations, then you can go to court to get judges to enforce these rights. Litigation, of course, is very expensive and difficult, but sometimes it is necessary. In the US, we have a very robust system of what we lawyers refer to as discovery, which is very important if you're in a dispute, to be able to understand what it is that the other side has done with your information. And if you can bring your case before a court, get that discovery, frequently you'll be able to prove that what they have done is inappropriate. And along the way, as you go through the process and each side learns more, you'll find opportunities to engage and figure out whether or not perhaps there's a way you can step away from the litigation and resolve the dispute and get what it is that you need voluntarily. Sometimes, not very often, but sometimes the way in which the information is taken shows a truly malicious intent. There have been cases that you've undoubtedly read about, hacking or other kinds of industrial espionage. And to cover that kind of behavior, we do have criminal laws in the US, both at the federal and in many states at the state level, in which the prosecutor will take over the enforcement of your rights. And this can be a very interesting way to get the other side's attention. If you can get the prosecutor to take over your case. But just be aware, if you do that, you will lose control over the case, including control over when it can get dismissed and how you can settle it. As far as enforcement of rights outside the United States, it's it varies a great deal according to what country you are in. If you're in Russia, very, very difficult. China is also, although it's getting better, very unpredictable. And most other countries, unlike the US, do not permit any discovery. And so your ability to find out what's happened to your information internationally is very limited. So what do you need to know? What should you be thinking about around enforcement? And most companies need to, first of all, focus on prevention of disputes and management of those relationships that I mentioned. Putting the kind of effort that you need to address those relationships and thereby prevent disputes is time very, very well spent, because once you're in a dispute, it takes on a life of its own. So the most important thing is try to stay out of it. If you are in it or see that it's coming and unavoidable in a sense, just be aware that this is not something where you can easily predict the outcome, and you're going to have to stay closely engaged with it through the time of discovery. And as if you go all the way to trial, as you prepare for trial and you think about the possible outcomes, just understand this is an area of the law where surprises can come up. In any event, whatever the ultimate outcome, you should keep in mind that trade secret litigation is expensive in terms of dollars that you're going to have to put into the effort. It's also an expense to the business in terms of distraction and diversion of attention, because everyone pays attention to this drama that's going on and they have to spend time with lawyers and so on. So productivity will suffer almost certainly. And then there is the issue of your other external relationships. Customers sometimes get annoyed when you're engaged in this sort of litigation. So think carefully about it. Prevention and focus on management is the right answer almost always. And if you do get into a dispute, put your energy into finding out if there's a way to resolve it short of going all the way to court. I once was involved in a mediation where I saw the parties be completely apart from one another, as angry as you can imagine, each side thinking that they were absolute victims of what the other side had done. And it was really hard to get them to talk to one another. It just wouldn't work at all. But in front of a professional mediator, they were able at least to share their story with the mediator, who in the process, and I watched this from one side, but with a great deal of interest, he was able to find within their stories a shared interest that became the germ of an ultimate settlement, where instead of going off to litigation, they actually entered into a new transaction with a new set of rules to govern their behavior that turned out to be very successful. So always keep in mind that hidden within a dispute may be the germ of a new deal.